Hey out there, legal warriors. In this video, I'm going to cover 3 big mistakes to avoid after your DUI case is over. If you're interested in that area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. Now I'm just going to jump right into it. So much of what we talk about as defense attorneys and on this YouTube station even is, hey, what to do while you're charged with a crime, or if you're going to be charged with a crime, what to do about that. And those things are important. But I was thinking in what I wanted to film here today was, what are some mistakes we need to avoid? And what have I seen out there for 30 years of doing this type of work? Mistakes that people make, the gotchas that can come up after their DUI case is resolved. And I think there's 3 major mistakes that I see people make. And I'm just going to jump into those right now. So mistake number 1 is not paying attention to their licensing status. This is a really big mistake. So depending on how your DUI was resolved, you may have a license suspension or you may not. And the court may trigger suspensions, but they don't actually tell you, here's your suspension starting on that date. If you're convicted of a DUI or some reductions of a DUI, some of those will trigger a suspension from Department of Licensing. How does that happen? Well, the court clerk, once the sentencing is done, sends in a notice to Department of Licensing, telling Department of Licensing what the conviction was. If it's a DUI, there's definitely going to be a suspension. Reduction to reckless will often carry a suspension as well. And then the Department of Licensing is going to process that and send out a notice to the driver saying, hey, you're going to be suspended on a certain date. They have to give you some time to challenge whether or not it was you in court, whether you were the one in court. So if it was like your brother, they give you a form to fill out and say, hey, it wasn't me, right? Someone was using my name. A suspension is going to start sometime after that conviction and sentencing notice is sent in. And sometimes people just don't open their mail and they don't see the suspension, or they don't have their address updated so they don't get the suspension notice. And why this is so important is because on a DUI probation, if you're actually convicted of DUI and you're caught driving without a license, there's a mandatory minimum 30 days in jail. The court has to put you in jail for 30 days, or sometimes a jail alternative, hopefully like home detention, if you are convicted of driving on a suspended license or even driving without a license. And if you're driving around not knowing you're suspended, well, that's not a defense I didn't know. And so many people are so happy to be over with the DUI, and they know that there's going to be suspension, but they got to get back to work and all this, and they don't pay attention. And so not knowing your licensing status is a huge deal. You can get on the Department of Licensing website, www.dol.wa.gov, and check your licensing status. And you can also ask your attorney, hey, attorney, how long do you think my suspension is going to be for? You can also call the Department of Licensing and ask them. They should be able to look it up and tell you. And not only do you need to know your status, you need to know how to get your license back. So many people do get a notice says, hey, I'm suspended for 90 days, and the 90 days are up, and they think their license just magically reappears. It doesn't. The license does not magically become valid after the suspension period is up. Depending on the type of conviction you have or reduction, there's different things you're going to have to do. And you can find out on your Licensing Express page exactly what you need to do. But in general, the gotchas are so many people. If let's say you got a DUI reduction, well, you're going to have to pay a reissue fee at the very least. You have to pay Department of Licensing some money to make your license valid again. If you have a DUI conviction, you're going to need to provide proof of treatment and pay some money to get your license back. Proof of treatment doesn't come from you, it comes from your treatment agency. There's a term of art called the blue sheet that your treatment agency needs to send in. And unless you tell the treatment agency to send it in, they're not going to send it in. They're not going to do work you don't tell them to do. So, hey, you didn't know your license was suspended. You didn't drive for the 90 days. or a year, however long it was, and that time passes, I'm good to drive now. If you didn't take any action, no, you're not good to drive. So you need to know your status. I want you to avoid a new crime. I want you to avoid a mandatory 30 days in jail. So what is the second mistake I see the most often? The second mistake I see the most often is people not doing their treatment that's ordered or not getting their treatment proof to the court, so it triggers probation violation hearings. On any type of DUI, there's going to have to be an alcohol evaluation and follow-up treatment, whatever's recommended, and also typically a DUI victims panel. Now, if you're a client of my firm, we're going to make sure all of that is either done or well systematized, and you're doing great before we would ever resolve the case. So these are people that would be calling me on the phone who we didn't represent, going, hey, I've got a probation problem. I say, what's the problem? Well, treatment. Great. Well, I pled out to something, but I hadn't even done my eval yet. No attorney should let you do that because it's creating too much risk for the client. But that's a mistake you can make. You've got to make sure that you do what the court ordered. I've even seen cases where the client did all the stuff, but the agency never got anything to the court, right? The agency is supposed to send it, but ultimately it's the client's responsibility to send the stuff to the court. If you have an attorney and you are doing treatment, make sure that the treatment agency is also sending the treatment proof to your attorney. Now, if you have a public defender, talk to them about how much they're going to help you. Not every firm is like mine. We get all the treatment reports. We monitor the treatment reports. If there's a problem, we let the client know, right? It's our job to try to protect the client from their mistakes, from agency mistakes, from court mistakes, but you ultimately have to protect yourself. So if we don't do the treatment, we're going to get called into court, or if the court doesn't have proof, we're going to get called into court. We could get put in jail. We have to spend more money for attorneys to defend ourselves. We have more stress. We have more problems, and that is really bad. So not doing what you're supposed to do, not doing the treatment, not having the proof of the treatment is mistake number 2. I think the third mistake that I see most people make, especially if they got something reduced, is simply not taking the future seriously enough. If you have an interlock on your car and you decide, hey, I'm going to drink anyway, and the interlock registers alcohol, some courts are still monitoring that interlock report. I can name a few, I won't do it here, that do monitor them, and I can name some that don't, just from having a high level of experience in Washington State. But, I just had a little sip, and my car didn't start, no big deal. No, it may generate a report, it may generate a probation violation, it may generate a lot of problems. Also, similarly, even if it's years later, we don't ever want to put ourselves in this position again where we might get a second or a third or whatnot, a DUI, right? Especially sometimes we see a young person who had a sort of a lower breath test first case to get the case reduced, and now 3 or 4 years later, here they are again in the same situation. Oh, it's not going to happen to me again. Or for whatever reason, they're there again, and the penalties are so much worse on a second offense and just dreadful on a third offense, and then we start talking about felonies after that. And no one should ever be drinking and driving and getting a DUI if they can avoid it. It endangers us all. It's not good for anybody. But I think that third mistake is when I see that repeat offender coming in, and I wonder in my brain, and I'm very sorry for them about how it is that we got in this situation again, because it's pretty traumatic to have a second offense. So I say a first offense is inconvenient, and probably in a standard case isn't going to be too destructive to us, but a second offense or more is much more damaging to our future. So I think those are the 3 big mistakes to avoid. And the interesting thing about them is they're all within your control, right? These are all things that anybody that's contacted me with new problems for us to fix, which we're going to do our best, we can fix most problems. But they're all things they could have avoided. And that's why, if you've had a DUI, hopefully you're watching this, and you might want to watch this anyway just to know things to avoid if you ever have to go through this terrible situation. So I hope you found this video useful. If so, please like and please subscribe. More people get the help they need. And more importantly, if you got some type of criminal issue in Washington State, feel free to give my office a call. If we get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.